Hello friends, welcome to EduSathi, your partner in education. In this video, we will be discussing the concepts of law of torts. These are trespass, vicarious liability, and assault and battery. So let's start. While discussing the concepts of law of torts, you would have understood till now what liability means. Liability is when you commit a wrongful act, you are held liable for the same. Let's take an example. A negligently drives his car into B and breaks his leg. A is liable to pay B for the damages. However, the concepts we are discussing today is vicarious liability, which is an exceptional rule to this rule of liability. Vicarious liability means being liable for an act which you have not committed. So this is possible only out of the act of authorization. You have not done the act, but you have authorized to do it or caused it to be done by other person. If you authorize someone to do certain act, the liabilities arising out of that act would make you liable for the damages which have been occurred to the other person. Let's take an example. A's driver negligently drives his car into B. C is liable for the act because he was driving, but A is also liable since C is his servant driving on behalf of him as a servant. So he has authorized C to drive his car. So the damages occurring to B out of this accident would also be paid by A, as he was the master of the driver. When does vicarious liability arise? It arises in two situations: when a tort is committed by a servant. So the important thing to be discussed here is master-servant relationship, which we will be discussing in detail. So it has to be committed by a servant. Secondly, a tort committed by an agent. In that, we will be discussing the concept of principal and agent relationship. So these are the two situations when the vicarious liability arises. Essentials of vicarious liability are: tort must be committed by these two persons, either servant or agent, and tort must be committed in the course of employment. So the important aspects which need to be understood during the whole discussion would be who's servant, and when does master-servant relationship arises, who's agent, and what does principal and agent relationship mean. So the tort must be committed by these two persons, and it must be committed during the course of employment. So we will be discussing all these aspects of the definition in detail. Who is a servant? First of all, we will discuss who would be a servant. Anybody who is employed by another to do the work under the directions and control of the person is a servant. For master is liable for the acts of the servant, there must be a master-servant relationship. For making master liable for the acts of a servant, there must be a master-servant relationship. So when does this relationship arise? There are two tests to determine whether this relationship is existing between the two persons involved or not. First is the hire and fire test. This implies that employment means master. M means master is the paymaster of S. He is the one who pays for the services of S, and M has the power to dismiss S. That means hire and fire test would mean anybody who is paymaster of a second person, who would be servant in this case, and has the power to dismiss that person would be considered to be the master of that person, and there will be a master-servant relationship by doing a hire-fire test. Second test is direction and control test. It means master is entitled to give binding orders to the servant, as in what to do and how to do it. For example, if a person hires a driver, so the master has a authority to tell him that how to drive a car and where to go and how to pick him up and drop the master. So these are the directions what masters can give. So these are the two tests which determine that there is a master-servant relationship. The tricky area involved in here is that all the independent contractors are not servants. For example, if you hire a taxi driver or electrician or plumber, etc., they are not the servants. They are particularly doing you've hired those persons to do particular work, and so these are the independent contractors, not the servants. Next thing we will have to discuss is who is an agent. Agent is a representative who acts on behalf of another person. Every act of the agent is viewed legally as the act of the principal. So you see the difference. In this case, a person is hired to work under the directions and control of the masters. However, agent is a person who is authorized as a representative, as in who would represent the person, the master or the principal. In this case, the person in principal agent relationship is principal. So the agent is a person who represents the principal everywhere, and all his acts would be considered legally to be done by the principal due to the authorization. The example is LIC agent, car salesman. For example, if you hire a LIC agent, that person would be representing you in front of the company for all your contracts and all the agreements entered into by LIC agent on your behalf. You would be liable for those agreements and contracts. The tricky area involved in this concept is this concept is also used in the partnership law, where all the partners are held liable for the partnership firm as an agents of each other. This concept is called as mutual agencies. For example, if there are 4 partners, these partners are liable for each other's act. If one partner enters into a contract on behalf of the firm, so other 3 partners would be held liable for the liabilities arising out of this contract, because this person is acting as an agent of other 3 and the partnership firm. So this concept is known as concept of mutual agency. Next thing we will discuss is course of employment. What does course of employment mean? For master and or principal to be liable for the acts of servant or agent, there must be a master servant relationship or a principal agent relationship, and this we have already discussed, and the act must be done in the course of employment or agency. So to make principal or master liable for the acts of agent or servant, he must have done that act in the course of employment or agency. So what are the what acts are considered to be in the course of employment and agency? If an act is done in a if act done is wrongful act authorized by master or principal. The example would be A asks his driver B to run his car into C. In this case, A has authorized his servant to do something what is wrongful act, to drive into somebody for entering into an accident. It is wrongful act, and A would be liable for the act done by B because he has authorized him to do wrongful act, and this act has been done in the course of employment. Next part is act done is lawful but is done using a wrongful and unauthorized mode. Authorized act done in a wrongful manner. The person has authorized you to do certain act and you use wrongful means to complete that act. For that act also the principal or master would be liable. Let's take an example for this also. A asks his driver B to pick him up from the airport. On the way to airport, B negligently drives his car into C and breaks his leg. A is liable. So in this case, the person has authorized him to pick him from airport. So while driving to the airport, B has negligently drive the car into C, breaking his leg. So during the course of employment, while he was driving to pick up his master, this would be the course of employment. So in this case, A would also be liable for the acts of B because the act is done during the course of employment. Next example, A appoints B as his agent to negotiate a deal for him in London. So in this case, it's a principal and agent relationship. A has appointed B to be his agent for negotiating a deal in London. During the negotiations, B fails to read the entire contract and negligently accepts a loss-making propositions. So in this case, we discussed a person who's acting on behalf. All the actions would be deemed to be done by the principal, which are done by the agent on his behalf. So if the person has failed to read the contract and negligently accepted certain conditions which are loss making, A would be liable for the contract which has been entered into, irrespective of the fact that B was negligent, because third party should not have some loss or something. If A backs out and says that I am not liable for the contract, the other party with whom the contract has been entered into would be at loss. So law says all the actions done by B as agent on behalf of A would make A liable for all the actions. What is an authorized act done in a wrongful manner? Authorized act itself is wrong and is not covered under the scope of authorization. How do we figure out what is authorized act done in a wrongful manner? There are two tests for the same. When the injury causing act was done, had he stopped during the authorized act? For example, A's driver B, while driving A's truck from X to Y, stops in middle and start beating his wife. Is A liable for the act? No, because A has authorized B to drive the truck, but he had stopped in between, so there was a authorized act halt. Matlab, the authorized act has been stopped in between, it was at halt while doing such beating of his wife. So A would not be held liable for this act of beating his wife, because he had stopped doing the authorized act, that is driving a truck. Another example would be A's driver B, while driving A's truck from X to Y, stops to get the fuel and beats the filling station operator, owner, or both. Is A liable for the same? The similar principle applies in here also, because the authorized act was A's driving the truck from X to Y and he had stopped doing that. So the beating of the filling station operator or owner would not be A's liability, so A would not be held liable for the act. So the test of authorized act halt test, AAHT, means if you have stopped doing the authorized act, anything wrong done during that halt would not make the principal or agent liable for the same. Next is, can the injury causing act be completely carved out from the authorized act? It means whether you can carve out or take out the injury causing act out of the whole scope of authorized act. You would understand it better with an example. A goes to a hotel where the cleaning lady C comes in his room. While cleaning the room, C steals A's laptop. Is hotel owner liable? No. Applying this principle, carving out test, the authorized act was room cleaning, not the stealing. So this act of stealing the laptop can be carved out of the authorized act of cleaning the room. So by carving out this act, the master, that is hotel owner, would not be held liable for the acts of C. So the test of carving out test would be applied here. Let's take a problem. Principle: a master is responsible for the negligent acts of his servant in the course of employment, which we have already discussed. Facts are: Ganesh gives his car for repairs to Axle and Gear Garage. One day, Jatin, an employee of the garage, takes the car out for test drive. While doing so, he injures a pedestrian because of his negligent driver. Who will be held liable? Ganesh, Jatin, and the garage or the garage. In this case, Jatin has done something during his course of employment, because he was test driving the car which he was repairing. So he has a master servant relationship with the garage. So applying the principle, the master would be liable for the negligent acts, which is negligent driving in this case, in the course of employment, which is taking the car for test drive. So in this case, applying this principle, the garage would be held liable. Let's take the options. First, garage is liable since it is his car. Ganesh is liable, since it is his car. So this cannot be an option, because he was nowhere involved in the negligent driving or any damage occurring thereto. The garage is liable because of vicarious liability. This can be an option. The garage and Jatin both are liable. No, in this case this would not be an option, because the garage is liable for the acts of Jatin. All three are liable? No, this is not an option. So the right answer is garage is liable because of vicarious liability. Let's take another problem. A master is liable for the acts of servant in the course of employment. Facts. Nathu is a truck driver for Poncho Transport Company. Nathu is given assignment of delivering some goods from Delhi to Mumbai. While on his way to Mumbai, Nathu gets off the highway to eat his lunch and starts refueling the truck at the next door petrol pump. While at the petrol pump, he has a huge fight with the attendant and wrongly accuses him of being thief in front of all the waiting crowd. The petrol pump attendant sues Poncho Transport Company for defamation. Will he succeed? So we've discussed this example in the previous slide also, that a person had entered into a fight with the petrol pump attendant. In this case also, the test of, let's go back to the authorized act halt test would apply, where the person has stopped doing the act, which is delivering goods from Delhi to Mumbai, and he had entered into this fight while he was not doing the act authorized by the principal, that is Poncho Transport Company or the master. So let's take the options. What is the right answer? The petrol pump attendant will succeed since Poncho's action occurred while he was filling the petrol. No, this is not the answer. The petrol pump attendant will fail since he had the fight at lunchtime. No, this cannot be an answer. So the last option is the petrol pump attendant will fail since Poncho's action are not connected with the authorized act. So he was not doing the authorized act while he entered into the fight. So this is the right answer by applying the authorized act halt test. Principle. A master is liable for all the acts of his servant done in the course of employment. Facts. Pritika, who is returning to Lucknow from Delhi, asks his driver Debashish to pick her from the airport at 7 am. Instead of taking the shortest route to airport, Debashish takes the longest route via the highway to enjoy the early morning breeze. Debashish is so engrossed in observing a group of girls passing by that he does not see an elderly man crossing the road and hits him. The old man sues Pritika for damage. We have already discussed the example in brief. So let's take the option directly. Debashish was not acting in the course of employment since he took the longer route unnecessarily. So this cannot be an option, even though he took the longer route, but he was driving to pick Pritika from the airport. So it's automatically the authorized act of driving to pick her up. Debashish and Pritika are liable. No, Debashish would not be liable since he was doing the act in the course of employment. C. Pritika is liable since Debashish was acting in the course of employment. Yes, this is an answer. D. Debashish alone is liable. No. So the last answer which is carved out is C. Pritika is liable for the act of Debashish since he was doing it in the course of employment. Next concept which we will discuss is the concept of trespass. Trespass is an unreasonable interference with the enjoyment of person's individual right or his property. Trespass is recognized both under law of torts as well as IPC. Trespass has been divided into two groups or two types, we can say. Trespass to the person or trespass to the property, both movable and immovable property. So trespass is an unreasonable interference with the enjoyment of person's individual right, which means trespass to the person, and or his property, which amounts to trespass to the property. So these are the two categories we will discuss in the next slides. As relation to trespass to property, there is another concept of encroachment. The concept of trespass is similar to encroachment, but it's not the same. Encroachment is actually taking your property away with wrongful means. Trespass, there might not be a wrongful means used. You would just simply enter somebody's property for not taking it away, or for not having a hold or possession of the property. In case of encroachment, the only intention is to have the possession of the property by wrongful means. Trespass has a broader scope, wherein you might just be entering for in any purpose in the property and not for taking the possession of the property. So they are similar to each other, and encroachment could be said to be the part of trespass, but trespass has a wider scope. Let's take an example. Trespass to land is interference to the possession of land without lawful justification. It's an interference to possession of land. You do not take the possession of the land as in the case of encroachment, like we already discussed. So that is the difference between trespass and encroachment. Let's take the facts. X hired Y to build a house on an empty plot of land. He soon found out that Y started living on the plot of land and was refusing to leave. He brought an action against Y for trespass. So in this case, the person has entered the land with the permission of X for doing certain act. However, later on he had started living there. So would it amount to trespass or not? Let's take the options. A. X will not succeed because Y was there on his authority. The authority was given to build the house, not to start living there. So this cannot be an option because he had not authorized Y to start living there. Second is X will succeed. This might be an answer. We will come back to it after taking the other options. C. X will succeed though he asked Y to enter his land. Y continued the presence. There was illegal and without lawful justification. So this answer is next stage to the option B, because it also explains the reason behind the success of X's lawsuit. Let's take another option. D. X has not action. X cannot. There's no tort, and he only has action under criminal law. So this option means that there is no action lying under tort and not only under the criminal law. So it says there would not be any action under the law of tort, but under the criminal law. So this cannot be an answer because we are not discussing the applicability of the law in this case. We are just discussing whether he will succeed or not. So these two can be the option. The closer option is option C, because it explains the reason wherein Y had entered the land with permission, but continuing to live there was illegal and without lawful justification. So this is the right answer in this case. Another concepts which we will be discussing in this PPT are assault and battery. Let's take them one by one. Assault in torts means an intentional act by one person that creates an apprehension in another of an imminent harmful and offensive contact. So let's take the ingredients of this tort of assault. An act intended to cause an apprehension of harmful or offensive contact. There has to be an intention to cause an apprehension of harmful and offensive contact. So the intention should be there and apprehension of harmful and offensive contact should be there. An act that causes apprehension in the victim's mind of harmful or offensive contact is imminent. That means it's immediately going to happen. It creates an apprehension that that person would be using the force to have a harmful and offensive contact. So it should be an imminent danger. Assault need not to involve actual contact. So it's a stage where there might not be an actual contact, but just a fear of such contact which is harmful and offensive. So there might not be an actual contact resulting. So it only needs intent and resulting apprehension. However, assault requires more than words alone. If somebody is abusing the other person very severely, in that case it would not amount to assault. The apprehension of using force, if you start taking your fist up like you're actually going to punch me, in that case it's an assault, because I will have an apprehension that you are actually going to punch me in my face. There might not be actual actual contact, but there's an apprehension in my mind that you're actually going to punch me. So this is an tort of assault. Let's take the next concept, which is related to assault. That's why we are discussing them together. Battery is a tort of intentionally and voluntarily bringing about an unconsented, harmful, and offensive contact with a person or to something closely associated with them. So, in this case, unlike assault, battery involves the actual contact. So, battery is the next stage to assault. I have an apprehension that you are going to punch me. It's a tort of assault. So once you punch me, it would result into battery. So assault results in battery in most cases, but it might not be happening in the all the cases. You might just try to create an apprehension, but you might not punch me. Actually, that would not amount to battery. So assault would result into battery when the actual contact comes into it. So it's a similar ingredients apply here. There is an intention and voluntariness, which for bringing about an unconsented, which is not, obviously it would not be a consented contact if it's harmful and offensive with the person. It could be with a person or something closely associated with them. For example, a hat or purse. You might be taking away my purse, and in that case you might be hurting me or my property. So this means it could be with a person or any property or something closely associated with them. Battery can occur without a preceding assault. They might not, you would not give me time of apprehension. If you directly come and punch me, in that case there is no assault, because I did not have any kind of apprehension in my mind. The act has actually resulted in battery directly. So there might not be preceding assault. It's not a mandatory thing. For example, if a person is stuck in the back of his head, if you hit me at the back of my head, there would not be any apprehension because I was not able to see you. So in that case, the battery would result without the preceding act of assault. So these are the two related concepts. One is where there's just apprehension of contact, and second is there is actual contact of harmful and offensive nature. Assault and battery: when a person threatens verbally or with body language or in any other way to bodily harm another person or persons, and this threat causes fear or panic in the person being threatened, then such a threat is defined as a assault. We've already discussed this. You can read it again. When a person physically hits another, then this act of violence is termed as battery. So there has to be a physical contact. An act of battery must harm, offend, or pain the receiver. There must be some kind of harm, offend, or pain. Even if act of battery is minor and it is not, it has caused offense, then the deliverer of violence can be charged of battery. There might not be much harm. It could be just a minor thing. If you hit me at the back of my head, it might not harm me much, but it has offended me in a way. So I can charge you of the offense of or the tort of battery. So the magnitude of the offense does not matter. It's the person who's the receiver would decide whether it has offended that person or has given any kind of harm or pain. So it would depend upon the receiver to decide whether it's a tort of battery or not. Assault is verbal or with an intent. A person does not have to say anything to threaten another person. He can move threateningly towards him, and that can be classified as assault, like we have already discussed. Stalking can be classified as assault. When a person is following you in a way that an apprehension of would be harm is created in your mind, that would also amount to an assault. Battery, on the other hand, is physical. We've already discussed that battery is a physical contact where you get a harm or offend. Example: wielding a knife while shouting threats could be construed as an assault if apprehension is created. Fear is not required, only anticipation of subsequent battery is there. So this is the concept. These are the concepts of assault and battery, which are quite simple. Let's take the problem. Principle: the tort of assault occurs when the defendant does something that causes a reasonable apprehension of battery, that is, use of force, in the mind of plaintiff. Facts: after a heated argument in a course of history lecture, Praneeth accosts Sandeep, calls him anti-Hindu, and tells him that he will die of painful death and rot in hell. Sandeep sues Praneeth for assault. In this case, we will see that there was no apprehension in the mind of Sandeep while Praneeth was actually abusing him in a way by saying him anti-Hindu and giving all these things that he will die a painful death and rot in hell. So in this case, applying this principle, there would not be any tort of assault because there has to be an apprehension. So there was no apprehension in this case. Let's take the options for the right answer. A. Praneeth is not liable for assault. This could be an answer. Praneeth is liable for assault since the circumstances of this case indicated that he intended to use force against Sandeep. Verbal words does not amount to the tort of assault, so this is not the right answer. C. Praneeth is liable for assault since his words were preceded by heated argument. No, the heated argument is also a verbal thing, so there is no apprehension resulting out of it, so this would not be an answer. Last option, Praneeth is liable for defamation. This is another concept. We are not getting into it. The only thing which we have to decide in this case is whether Sandeep would succeed in the case of tort against Praneeth for the tort of assault or not. So this is the different concept and does not get into the question. So the right answer is Praneeth would not be held liable for assault because there was no apprehension created in the mind of Sandeep. So thank you. Hope the concepts of assault, battery, trespass and the liability are clear to you. Thank you for being with us.